auspices of Section 91, subsection 3.
Yes.
I shall, in the ultimate analysis, deal with the issue of the lawfulness or otherwise of the decision to prorogue Parliament by the First Minister. And I'll deal with those issues in that chronological order the court permitting.
Yes.
I beg your pardon, my lord. Now, my humble submission, my lords, is that.
Sorry, Mr. Raskin.
I beg your pardon.
You said you're going to deal with prayer 2.5.
I beg your pardon,
Prayer 2.5.
Yes.
Is that competent, really, in the circumstances of this case?
Well, the context in which I'm going to argue it's as ancillary relief of an interest. But
because you're saying we should interdict the Prime Minister from proroguing Parliament.
I'll apply my mind, Your Lordship, to this issue and I'll confer with my colleagues. If there's any need for me not to pursue it as well, I'll do so.
Okay.
But as to the rest of the players, I insist on being pursued.
Okay.
That's the problem. Now, my lords and my lady, with your permission, may I deal with the issue of local standard in very brief terms? My lords and my lady will recall the decision of the Prorogation and Portfolio case, which went all the way to the Apex Court, the Court of Appeal. The court will recall that in that decision, specifically in the decision of Portfolio, which was consolidated with the one of Mufomovi, there were two applicants before court. The other applicant was a member of the National Assembly, being Chief Dwamula. And the issues on the radar in that case had to do with the dissolution of Parliament. And what the Court of Appeal said, insofar as that point of local standard is concerned, to the extent of the interest of the legislature, in particular the member of the National Assembly is this, and with your permission may I quote. This is in paragraph 31 of the decision of the Apex Court. It reads, and I quote, "We have no hesitation to find that as a member of Parliament, Chief Mulap was standing to institute the proceedings in Portfolio is clearly established by reason thereof. We observe also that there was some discussion about whether Chief Mulap is a party to the appeal in Portfolio. We are prepared to accept council submissions that he is and that omission of his name from the appeal papers was due to inadvertence. This is more so because the order of course that we intend to make is such that he cannot possibly suffer any prejudice," unquote. Now, I am quoting this dictum, Your Lordship, which accurately reflects the position of law on this issue because it is equally of equal force in the instant case. My clients are members of Parliament, some are in Senate, some are in the National Assembly. They clearly have an interest on an issue that has to do with the prorogation of Parliament, and I need not say anything beyond this except to say that this decision is spot on and it's binding on this court. With your permission, my lords, if I may then move on to the next point, the point of non-joinder. On the same note, Your Lordship, I submit that what my colleague Mr. Ndebele adverted to by quoting verbatim what we have stated in our heads of argument, that the joinder of the Honorable Attorney General adequately does away with that point, and I need not say anything beyond that. We have dealt with the issue in our heads in paragraph 5.23 up right into paragraph 5.26. Now, my lords, with your permission, may I directly go into the issue of the validity of the Gazette. My humble submission, Your Lordship, is that, and my lady, we have to first, or rather our point of departure has to be section 91, subsection 3 of the Constitution. And I must say that this is a very monumental case because this is the first time when the issue that has to do with the operationalization of this provision is on the radar before the Court of Law in this jurisdiction. My humble submission is that for the Prime Minister to have validly acted in line with that provision, there are several jurisdictional requirements which have to be satisfied. And with your permission, my lords and my ladies, if the court would be minded to go to our heads in page 7, paragraph 2.6. And perhaps, with your permission, my lords and my ladies, I'll go through those verbatim just to give meaning to my submissions in a coherent manner. We submit that His Majesty, having not signed or consented to the prorogation instrument, one would have expected the Prime Minister to act in terms of section 91, subsection 2, and to meet all the mandatory requirements spelled out thereof. It is common cause that the Prime Minister does not allege in his answering affidavit, nor does Annexure ABC 1 express the mention that A, which we submit to be the first jurisdictional requirement. 1, you are satisfied that His Majesty did not consent or sign the instruments facilitating the prorogation of Parliament. 2,
Can you repeat? Sorry, Mr. Scott, can you repeat that?
He was satisfied
Yes.
that His Majesty the King did not consent or sign the instruments facilitating the prorogation of Parliament. B, he either verbally or by letter informed His Majesty the King that it is his intention to do the act himself after the expiration of a period specified therein. C, and perhaps significantly, he has not stated, we submit, in his answering affidavit that in line with the requirement captioned in the paragraph A above, to which we have already adverted, the prescribed time frame had lapsed. D, and equally important, to date, and as at the filing of the answering affidavit, he has not disclosed when he reported, or at the very least, when he intended to report to Parliament. Now, if I may qualify this point, which I submit to be the Achilles heel of the First Minister in this case, my humble submission is that jurisprudentially, and as further supported by our constitutional democracy, the First Minister or the entire executive, inclusive of the First Minister, because the First Minister is part of the executive, is accountable to Parliament. Now, the decision to prorogue Parliament is of great national importance, such that it was imperative for the Prime Minister, in line with the very provision to which we have already adverted, being section 91, subsection 3, to report to Parliament. And these are courts with the core ethos and the jurisprudence in this, of our Constitution, and the jurisprudence in this jurisdiction. He's silent on that issue. Now, we submit further in a subsequent paragraph that the constitutional requirement stipulated and expressed in paragraph 2.6d, that is that of reporting to Parliament, was not met and could not be met inevitably because the Parliament has been prorogued after all. This constitutional provision upon which the Prime Minister purports to rely upon places on him, in our humble submission, the constitutional responsibility as the only repository of power to advise on prorogation, to have regard on all relevant interests, specifically, and for that matter, the parliament, the very parliament that he seeks to prorogue, he has not informed us on this aspect. It is respectfully submitted that none other than political parties and legislators would have the requisite legal capacity to challenge the breach of this constitutional obligation by the Prime Minister. And with effect, my lords and my lady, the notion of legality or constitutionality, or there is utter and downright breach of the very provision to which the First Minister purports to be acting on the basis of. And my lord, I submit that this is the sounding death knell to the cause of the first respondent and the second respondent. Now, my lords, with your permission.
The second respondent, Mr. Asquai, does he have any place, constitutionally speaking, when it comes to prorogation?
In terms of the Constitution, the answer is in the negative.
Sorry?
He doesn't have any place, I beg your pardon, my lord.
Okay.
He doesn't have any role in terms of the Constitution.
Okay.
The role is enjoyed exclusively by the First Minister. Now, with your permission, my lords, can I now venture into the lawfulness or otherwise of the decision to prorogue Parliament? The locus classicus case of Miller, it's of persuasive precedence granted, but to the extent of our administrative law, my humble submission is that it's applicable in this case. Now, in particular, in our constitutional law setting, in paragraph 55 of that judgment, on the interrogation or whether the court seeks to probe the lawfulness or otherwise of the decision to prorogue Parliament in that jurisdiction, and the last sentence for that matter, or rather, may I read paragraph 55 in its entirety in that decision, and I quote, "Let us remind ourselves of the foundations of our Constitution. We live in a representative democracy. The House of Commons exists because the people have elected its members. The government is not directly elected by the people, unlike the position in some other democracies. The government exists because it has the confidence of the House of Commons. It has no democratic legitimacy other than that. This means that it is accountable to the House of Commons and indeed to the House of Lords for its actions, remembering always that the actual task of government is for the executive and not for the Parliament or the courts." And quite significantly, with your permission, my lord, the first question, therefore, is whether the Prime Minister's action had the effect of frustrating or preventing the constitutional role of Parliament in holding the government to account. May I repeat? The first question, therefore, is whether the Prime Minister's action in this case had the effect of frustrating or preventing the constitutional role of Parliament in holding the government to account. Now, I'll stage that as a rhetorical question, Your Lordship, and apply it within the context of this case. My humble submission is that in order to assess or to evaluate whether this decision of the First Minister is lawful, we have to probe the facts pleaded and assess whether such facts elicit the conclusion that the aim of the First Minister was to frustrate or to prevent the constitutional role of Parliament in holding the very same government which he leads to account. Now, we know, and this is undisputed, that two coalition leaders who are part of the same coalition that he leads were not in support by the Prime Minister's own admission of the prorogation. 2, we know that the cabinet meeting only talked of the measures that have to be undertaken in combating coronavirus or the declaration of national emergency. I submit that nowhere does the cabinet minutes reflect that there was a unanimous or a binding decision that Parliament has to be prorogued. Nowhere, in my humble submission. So, beyond that, my lords and my lady, we know, as a matter of fact, that the next Monday, subsequent to the publication and invocation of this prorogation, the issues that have to do with the budget were going to be discussed, which are of serious importance in the administration of the state. 2, we know that a bill of grave importance that aimed to curtail the powers of the same First Minister had been passed and was yet to go to the upper house. 3, we know that the issues, just to illustrate that this issue of coronavirus is nothing but a red herring, that Chief Tisile Masribani himself was the chairperson of a committee that was tasked with dealing with issues that have to do with coronavirus. Now, the cumulative impact of all these factors clearly point towards the fact that the effect of this decision, with all of its flaws or maladies, for want of a better word, I beg your pardon, my lord, inclusive of the vote of no confidence, there was an impending vote of no confidence to the same First Minister. So much so that the cumulative impact of all these factors, it can safely be inferred or reasonably concluded that it was aimed at frustrating all those, inclusive of those that had a direct bearing on his capacity as a sitting Prime Minister.
So are you then suggesting, Mr. Raskwai, that that was the motive of prorogation, or is this not a necessary consequence of the exercise, the power, the invocation of the power to prorogue?
That's I agree, Your Lordship, is the ripple effect. But my humble submission is that
I understand you are saying
yes,
this had the effect of frustrating
precisely
Parliament.
Yes.
You see.
On his ordinary business, inclusive of business that had a bearing on him as a sitting Prime Minister, the vote of no confidence and the bill that was aimed at curtailing his powers to go to rush to His Majesty.
But shouldn't we perhaps say, isn't the test this? Let me put it this way: shouldn't we interrogate the reasonableness or justification of the reasons to prorogue? Because we cannot judge the motives, isn't it?
Precisely.
Yeah.
Precisely.
Isn't the legal test, isn't it simply this?
Yes.
What are the reasons? Are they legally justifiable? According to Miller, isn't it? I rather forget whether it's paragraph 30 if you read it with paragraph 60-something. But I'm merely saying, since our business is not good to go into the motive, shouldn't we then focus on whether or not, what were the reasons given, if there are any reasons given, on the disclosed documents?
The answer is in the affirmative, Your Lordship.
And if the reason given is corona, I don't know, you'll remind me, is it coronavirus?
Yes, it is.
According to which document? Is there any document, or is it a vehemence?
There's a cabinet paper in motivation of...
A cabinet decision?
Yes.
My understanding of your submission is that that cabinet decision is mum on prorogation. So you're saying that we should not even bother about.
Precisely.
You see?
Precisely. The annexure ABC1 is
Paragraph?
page 30.
I mean page 30 of the record.
Page 30 of our record.
No, that's not the cabinet decision, Mr. Ospaisen.
Oh, his lordship was.
I'm saying we want to get the sequence because we want to find or test whether there were any reasons and whether they were legally justifiable.
I beg your pardon, may I locate the cabinet? The cabinet paper is in page 82, right to page 84, your lordship, in my name.
82.
Yes.
So you are saying on the pleaded facts, on your case is that the first document that we have to look at is that letter.
And it's, in my humble submission, your lordship, it's silent on the issue of prorogation.
Is dated 19 March, isn't it?
19th of March.
Yes. I'm just trying to tease out the sequence.
As the court.
And document number 2, according to your submission, which one followed after that?
Page 31. Page 30, your lordship.
That's the letter,
Yes.
ABC1.
ABC1, which spills over to page 31.
That's
In page 31 is the instrument, but
20th March 2020.
that's the court.
And then the notice, isn't it?
Precisely.
The legal notice
And then the legal notice.
after the ABC1.
Precisely. Legal notice.
That's of 20th March as well. Isn't it?
Precisely.
Which is which then? Which gave birth to which?
The,
Is the prorogation a progeny of cabinet decision
this is
or ABC1? Which is which? In your submission, the way you have pleaded your case, what's the sequence?
what is pleaded by the Prime Minister is that the cabinet.
No, I'm saying on your side. We'll come to the Prime Minister's side. What's your approach? How do you say we should interrogate, sequence them, and interrogate them?
The sequence is this, that there was a cabinet meeting. In that cabinet meeting, there was a conclusive decision to the effect that coronavirus, as we declared as
An emergency.
an emergency.
That's on the 19th.
That is on the 19th.
Yeah.
And nowhere does the document refer to the issue of prorogation.
Yes.
Now, subsequent to that meeting, then there was this meeting between the parties, being the coalition leaders and the government secretary and the attorney general and Honorable Zekele, where the eventual outcome of that decision gave birth to this gazette. Eventually.
No. I'm not on the meetings. I'm on the documents, on the annexures. ABC1,
Yes.
20th March 2020. Prorogation, 20th March 2020. Which one was conceived first and necessarily born first?
The first.
Unless the gestation period took a longer time.
Yes. The first I submit your lordship was the cabinet meeting, and then ABC1 came to the mold, and then subsequently the publication.
Okay.
Yes.
So that's the approach you say we should take.
That is the proposed approach in my humble.
Okay. Now, on the disclosed documents, you are saying those are the only documents which would give us a scale to test, would give us the reasons, and also to then later on test whether they are legally justifiable.
Precisely, my lord.
Yeah.
That is my humble submission.
Yeah. Then you're talking about what is also pleaded.
Precisely.
I suppose what is pleaded is denied unless it's common cause.
Well,
That is this meeting you are talking about. What is said about it?
well, my line of submission is this, Your Lordship.
Okay.
In probing the lawfulness or otherwise of this decision, there has to be
No, the reason,
I beg your pardon, Your
whether
Lordship.
the reasons are justifiable,
Precisely.
legally justifiable.
Yes. And my humble submission is that the pleaded facts
Yes.
by the First Minister,
Yes.
coupled with the other surrounding factors, clearly point towards the fact that it was not justifiable and hence unlawful.
Which are those facts
Now,
pleaded by the Prime Minister?
note the facts pleaded by the applicants. The
Oh, but-
applicants
okay.
are saying, one, amongst others, there was a bill that was aimed at curtailing the powers of the very same repository of power, the First Minister. That's number one. Two,
But I thought we agreed that that's collateral damage or the necessary consequence of prorogation.
no, Your Lordship,
Because whatever happens, if Parliament is prorogued, everything shuts down.
That's the real
Or is killed, let me put it that way. It's killed.
yes.
So what we are looking at is not the, or are you saying there's a reason that the Prime Minister gave, which was that he wanted to kill that bill and others?
No, he
So
wouldn't-
what reasons has he pleaded?
He wouldn't. He
What
wouldn't-
reasons has he
The
pleaded?
Prime Minister's position is that this pandemic
Yes.
is so severe that the prorogation is justifiable. And our counter argument is that no, that's not the proper justification. There are factors which animated these decisions or this decision.
Yeah,
And
but
these
you
factors
see,
are the following.
but if he discloses that these are my reasons,
Yes.
aren't we supposed to now test them? Not
Precisely.
what you might infer or supposed to have been, because he's under oath, he says, these are my reasons.
Yes.
And you are saying the reasons are corona.
Yes. Now,
If he goes to His Majesty and says, I advise Your Majesty to prorogue Parliament on the only reason of coronavirus,
yes.
if he says that, and Parliament is prorogued as a result, I understand then you are saying the Prime Minister might have achieved indirectly his motives.
In fact,
Because
I think
if the
that-
advice is accepted, then it benefits him. That I understand. But I'm saying, but is it not what happens in the normal course of prorogation? That every bill, whether it affects him, it affects so and so, is going to be killed. And according to Miller, as I understand it, we have to now, if he gives reasons, we then have to then find out whether those reasons are legally justifiable.
Precisely, that's the position. In fact, Your Lordship, if I may go a step further,
Yes.
there's a very important decision that we have cited in our heads of argument.
Yes.
I beg your pardon, my Lord, may I organize myself? In paragraph, page 28, paragraph 6.10
Of the record.
of our heads of
Okay.
argument.
Okay. Sorry. Yes.
That is page 28 of our head.
Yeah.
Now, in page 28 of our heads, Your Lordship, we refer to the decision of Amasoni versus Attorney General. Now, I accept, in my humble submission, Your Lordships, that this decision carries a degree of persuasive precedence. But the court will observe that that decision comes from a state which is utilizing the Westminster model.
Which country is that?
It's the state of Tuvalu,
Or Tuvalu?
precisely, Your Lordship.
You'll give us a copy of the judgment if you have it.
I'll have it printed, Your Lordship.
Okay.
I beg your pardon.
Yeah.
In this decision, the court accepted that where the evidence suggests that the advice is motivated by a desire to avoid possible defeat in Parliament and would flout the spirit of the Constitution, the Governor General was entitled to take the view that it was impracticable to act upon such advice, as to do so would be inconsistent with democratic government, unquote. Now, my humble submission
So
is
what's
that
the principle? Is the principle...
is that in the assessment of lawfulness, the court has to evaluate the evidence presented before it in order to make a conclusive finding whether or not indeed there was that desire to defeat the very objectives of Parliament. If the answer is in the affirmative, then logically, in my humble submission, it follows that that decision is unlawful.
Would I be correct to put it this way?
Yes.
That the principle is that the Prime Minister cannot prorogue Parliament or advise Parliament to be prorogued in order to benefit himself.
That's one way of putting it, Your Lordship, and I couldn't have said it any better. Because that would evidently be unlawful, which is precisely what we are saying in the context of this case.
Yeah, but then we are going back to the motives issue, you see, Mr. Ashway.
Well,
Because it seems, according to Miller, the motives are irrelevant. What happened? What matters is the legal justification. And I thought when you talked about the conditions precedent, you'd rest your case there, but I understand that you are saying, no, that's not enough, I'm going further. To say that, look, now what has happened is that it was not just a failure not to engage with the king appropriately. He actually now was serving. This was a self-serving prorogation.
This is what we have pleaded, Your Lordship.
Yes.
Yes. This is what we have pleaded.
And you say that is the judge, the authority that you have just quoted to us.
Precisely.
Okay.
And beyond my humble submission, Your Lordship, beyond the fact that this decision is self-serving, the impact of this is to render the entire executive not responsible to the very legislative branch of government without a justifiable cause.
Now, as I understand the scheme of the Constitution, 83 are the powers of the king to prorogue, isn't it?
Yes.
Is it 83? Sorry. Yes.
Yes, Your Lordship.
You see?
Section 83.
Yes. And those are the powers of the king only. The default position is that in the event that the king fails to act, the Prime Minister will invoke his powers under 91.3.
Precisely.
In other words, 83 powers are not a shared responsibility.
Precisely, Your Lordship.
It's only the king who should prorogue.
Precisely.
But in the event that the king fails to prorogue, then the Prime Minister will invoke 91.3.
Yes.
But before he does that, he should notify His Majesty or inform him of his intention
Precisely.
to do what the king failed to do, and give the king a period. He should specify a period
Indeed.
so that the king can also, in the light of the intentions of the prime minister, decide whether or not he is ultimately going to prorogue, isn't it?
That is so, Your Lordship.
Only after that period has expired will the prime minister then prorogue. And by legal fiction, that prorogation is an act of the king, isn't it?
Precisely.
And then report the matter to Parliament at the earliest opportunity thereafter.
Precisely.
But we know that what happened here was that there was prorogation.
So there is no Parliament.
So there was no Parliament.
Precisely. And that cannot, the purposive interpretation that can be accorded to this section cannot be such that he has a fair conflict, for want of a better way,
Yeah.
not to report to Parliament when he invokes or exercises powers under this provision.
So should I understand that to be your first argument?
That is my first argument.
So this one of collateral damage is the second argument.
Precisely, that's exactly what I said, Your Lordship.
Okay.
That's exactly what I said.
Yes, proceed.
Yes.
Mr. Asquai,
My Lord,
let me understand you correctly before you proceed. ABC 1, the last paragraph, can that paragraph be understood to be putting His Majesty in moral as regards his response to the prorogation issue?
I beg your pardon, Your Lordship.
If you look at the last paragraph,
Of Annex ABC.
ABC 1, yes.
Yes.
It says to His Majesty, I'm intending on proroguing Parliament,
Yes.
but I'm intending on advising you to prorogue Parliament, but act by 21 hours, 9 o'clock.
Yes.
Yes. Can we interpret that to be saying that the PM actually put His Majesty to terms, as per Section 91(3)?
That may very well be so. But the question that we have to pose is it reasonable, given
So the issue really here is not whether His Majesty was put to terms, for want of better terms. The issue really is whether he was given a reasonable time.
No, I don't see it as more of a reasonable time. I see it more as an ultimatum, and I'll try to motivate why I say so.
It will be unreasonable because it's an ultimatum.
Precisely.
You see, Mr. Rashford.
And
In other words, the issue would be whether the First Minister,
yes,
the Constitution says he should give ultimatums to the King.
precisely.
And you are saying that's not the construction that we should give to the Constitution.
That cannot be. And
Yeah.
in fact, Your Lordship, in our heads of argument, we have engaged in a comparative study of
Yes.
similarly structured Westminster structured constitutions of the Cook Islands and also Tuvalu,
Yes.
where the similar provision is given an express period of time upon which the head of state ought to have acted. And none of them say 2 hours. The other one says 14 days, the other one says 7 days. So the question, the rhetorical one which I'm going to answer is this. As head of government, of the same head of state, because you are a constitutional monarch, can you go to His Majesty the King and say to him, I give you an ultimatum to do this within 2 hours, on such a far-reaching and overreaching and crucial issue as the closure or prorogation of Parliament? 2 hours. Can you do that? And my humble submission is that the answer lies in the decision of Solomon versus the Prime Minister, where the Prime Minister did exactly the same thing. And this is what His Lordship Mr. Justice Makara had to say. I beg your pardon. I beg your pardon, my Lord. Now, my lords would be minded and my lady to go to page 13 of our heads. Page 13 of our heads, my lords and my lady, where His Lordship, Mr. Justice Makara, had the following to say. And the court will observe that a similar letter had been written to the head of state by the head of government, the subordinate of the same head of state,
Yes.
where he was given an ultimatum of 2 hours to remove a person who is the head of the most important law enforcement institution, the mounted police. Now, this is what His Lordship, Mr. Justice Makara, had to say about this.
Which paragraph?
I beg your pardon.
Paragraph?
Page 30.
No, the judgment doesn't have paragraphs.
5.5, Your Lordship.
Yes.
And I quote, in
Now, the
advising...
question was in relation to which paragraph of the judgment to which you're referring.
Oh, I
Yeah.
beg your pardon, my lord, please get that.
Oh, it doesn't have paragraphs, Mr. Rasquai. Give us
Yeah, it's paragraph 5 to paragraph 7, Your Lordship.
5 to 7. Paras 5 to 7.
May I verify, Your Lordship? I seem to have inadvertently not captured the paragraph.
Give us the page then, Mr. Rasquai. If it has a page anyway.
It does, Your Lordship.
Which page is that?
I beg your pardon, my lord. It's in page, paragraph 46.
46. Yes.
I beg your pardon, my lord. May I?
Anyway, you can read it, then we'll look at it, Mr. Rasquai.
It's paragraph 62 right through to paragraph 61 of the same judgment.
62, 61, yes?
Yes, it reads as thus, and I quote, "It is found inconceivable in law that the first respondent had the authority to forthwith suspend the applicant from office pending a resolution of the advice by His Majesty the King. Instead, the latter, and I want to underscore this portion, Your Lordship, with your permission. Instead, the latter should be accorded due time to consider the recommendation, since he is entitled to ask for its elucidation before making a decision thereon. The fact that he is a constitutional monarch does not deprive him of the human right to thoughtfully consider any advice that he is requested to endorse by placing his signature and royal seal thereon. His judgment and conscience as a human being should be recognized." I want to repeat this. The judgment of His Majesty the King and conscience as a human being should be recognized. His Majesty the King is analogous to all state officials entitled to a presumption of law that he always acts correctly, timelessly, and in good faith or mere praesumtum rite esse acta. It sounds unorthodox for the Prime Minister to give His Majesty the King an ultimatum for him to act as requested, unquote. I repeat this. It sounds unorthodox for the Prime Minister to give His Majesty the King hardly 2 hours, an ultimatum for him to act as requested.
But with respect to our colleague, when he uses the word unorthodox, if you have a maverick prime minister, what are you going to do, Mr. Rasquai? Unorthodox, he doesn't,
If you have
unorthodox.
and I'm saying it
What is the orthodox? You see, it begs the question, what would be the orthodox?
well,
Because I would have thought that the McKennedy judgment articulates the rights of the king better.
precisely,
Because in McKennedy, it's very clear that the king has the right to be consulted, to advise and to warn.
in fact, Section 92 of our
Yes.
Constitution It's quite detailed.
Those are rights are in section 92. You
Precisely.
see.
And
So isn't that really the context to say, what are the rights of the king vis-a-vis an advice
precisely,
that is given?
precisely, which
Yeah.
is
Not an orthodoxy, but
I
you see, it's just that.
the formula is in the
Yes,
same,
so-
but
so-
the context is otherwise that.
Yeah,
A head of
but I understand the intention really to say maybe those are the issues. If I may, looking at ABC1 itself, it's written on the 20th, isn't it?
That is correct. Your Lordship.
And it actually says to His Majesty, I hereby advise His Majesty to prorogue Parliament. Isn't it? That is paragraph 1. And the reason appears in paragraph 2, isn't it?
That is correct. Your Lordship.
You see? Then the last paragraph is the one which now puts His Majesty to terms.
Gives an ultimatum.
It puts His Majesty to terms.
Yes, the court.
Now let's look at 91.3. Is that how it should be?
The answer
Because when I read 91.3, it says that the Prime Minister should first be satisfied the King has not acted.
that is so.
And then the Prime Minister may inform the King of his intention to do what His Majesty was supposed to do at the expiry of the period to be specified by the Prime Minister. Was that done here?
It wasn't.
That expresses the letter, at least. I don't know on the affidavits, but on the letter, what was done under the penultimate paragraph,
Yes,
is just to put His Majesty to terms,
precisely.
without indicating that in the event that by 9 o'clock, come 9 o'clock, 9 p.m., His Majesty hasn't signed, then I'll be constrained to invoke my powers under Section 91.3.
Precisely.
Yeah.
In fact, this is exactly what we are saying. If His Lordship would go to the paragraph 2.6 of our head.
Yeah.
Not all of the jurisdictional requirements that give flesh to this section or the invocation of this section have been satisfied. Hence, this decision in my humble submission is a nullity.
Mr. Square, let's deal with the sequencing here. When the Prime Minister invokes the default position under 91.3,
Yes.
what should come first? Should the Prime Minister then tell Parliament before he prorogues it? Or should he prorogue Parliament and then what should happen first? Because to me it presupposes that when Prime Minister prorogues Parliament, he cannot thereafter inform it.
Post factum.
Post facto,
This
yes.
is exactly the.
How should that happen? Should the Prime Minister then first, before proroguing Parliament, inform Parliament that His Majesty similarly is dragging his feet on this issue,
Yes.
and I'm intent on triggering 91.3.
This is exactly how it's supposed to be operationalized. Because if he has to go to Parliament post effect, then it means it's inconsequential. The Parliament, in my humble submission, has to sanction this initiative. Otherwise, if we interpret it, otherwise it effectively means we are giving the head of government a fait accompli over his boss, being the head of state.
So that's where undermining Parliament would come in.
Precisely. And
That is in the prorogation decision-making process.
precisely, and I'm having to bite my tongue when I say that even His Majesty himself is also being undermined. But I'm saying this having to bite my tongue, Your Lordship, because
But
that cannot be the constitutional scheme of things that, or interpretation that we can accord to this section in my humble submission.
so that reporting obligation to Parliament, Mr. Asquai,
Should precede the decision to prorogue. That's my humble submission.
no, isn't it the other way around that at the expiry of that period, if at the expiration of that period the King has not done that act, the Prime Minister may do that act himself and shall, at the earliest opportunity, thereafter,
After the decline in his
no, after he has actually now prorogued himself.
well,
He says, I'm now proroguing because you have failed to act, His Majesty. I'm proroguing, but then I'm going to inform Parliament of what I've already done.
Then
And that will be deemed by legal fiction to be your act.
My humble submission is that it would be self-defeating.
No, I'm saying the construction, the proper construction is that
Yes.
the reporting to Parliament presupposes that he reports his own act as the PM,
Precisely.
which is the act of the king by legal fiction.
Precisely. That's how it's supposed to be operational.
Yeah, in other words, the prorogation by the Prime Minister would have, under the hand of the Prime Minister, would have been effected. So he then, as a member of Parliament, has to report that this is what I have done. Because I suppose that is a very serious constitutional issue, really, for the PM to overreach the Prime Minister.
Precisely. That's
So if he does that, then the Parliament should actually be informed of that act.
precisely.
Now the reporting itself, the mechanics of reporting. Mr. Rasco, is it just a matter of saying to Parliament, this is what I did and the king failed to act, then I've acted, then we should deem it that he has acted? And isn't Parliament itself, once the report comes, supposed to deliberate on it? And maybe, since the Prime Minister is accountable to Parliament, actually interrogate the Prime Minister himself to say, really, what forced you to overreach the king? What were the reasons?
Well, my humble submission is that if the interpretation that we are according on this dynamic of Parliament is that the Parliament has to be reported to post the event,
Yes.
then that would effectively mean that it's self-defeating. My humble submission is
No, I don't quite follow that. How is it self-defeating?
It's self-defeating in the following sense.
I'm saying the Prime Minister has already prorogued Parliament.
Yes.
You see?
Yes.
But then he has to now report the act of proroguing Parliament to Parliament at the earliest of opportunity thereafter.
How can that happen when Parliament is prorogued? That's a rhetorical question that we would have to put. That's not the interpretation that we have to accord.
Does that not now talk to the issue as to the reasonable period within which prorogation should be done? Because if he prorogues it for 3 months, then it will be self-defeating. But if Parliament is prorogued for 2 to 3 weeks, according to Miller, as I recall, because Miller suggests that, given the situation, only 2 to 3 weeks would have been necessary to prorogue.
Precisely.
You see? Now, I'm saying now, I want to understand now here, if the Prime Minister prorogues Parliament for 3 months, it means the earliest opportunity is of his own choosing here. Is that how we should interpret the Constitution? That by design of proroguing it for a long time, then he says, I'll only report when they're in session. And in any event, I would have achieved what I wanted to advise them. I would have achieved the purpose of the advice.
Well, my humble submission is Your Lordship, this is not how I envisage the interpretation that has to be accorded to that section. The humble submission which I am making is that this reporting to Parliament has to be done whilst the Parliament is in session. So that if Parliament is against the initiative, Parliament can be a blush to reproach, for want of a better word, the First Minister for that initiative.
But if Mr. Rasquai has already done the act, are you saying he can do the act, but says it shall not take effect until I've reported to Parliament? Are you saying we should approach it that way? Or should it be the case that that reporting presupposes that the earliest opportunity presupposes that Parliament would not have been prorogued for an unreasonable period?
The latter proposition, Your Lordship, holds true. I support it. My humble submission is that it effect post reporting to Parliament. That's how, as far as I can take it, Your Worship.
So in other words, the act itself will only take effect after Parliament has been reported.
As the court.
In Kasu, if the act was done on the 20th of March,
At night,
what date was it?
20th March, Your Lordship.
It was a weekend.
It was a Friday and
It was a Friday.
Yes, and Parliament was not Friday evening or night, and the Parliament was not in session.
Yeah. So the earliest opportunity would be the following Monday.
Precisely.
And did I understand the papers correctly to suggest that when the MPs reported, they were chased away by policemen in Parliament?
So, Your Lordship. That is so.
That is on a Monday.
Precisely.
Should you assume then that the police got instructions from the PM?
It's safe to be fair. It's safe to be fair.
Okay.
Now,
So the earliest opportunity on the facts would be after the prorogation in June,
precisely,
on the facts.
on the facts.
And you are saying that's not what the section envisages. It envisages that prorogation will only take effect after Parliament has been reported that you are now being prorogued.
As the court pleases.
Yeah. Isn't part of the problem that in this jurisdiction we don't have a ceremony akin to Britain, where the prorogation is actually a ceremony? You
Well,
see?
my take.
What might call messengers from Her Majesty's office will come to Parliament dressed in the manner that they are dressed, deliver the letter to the Speaker of the House that it has pleased Her Majesty to prorogue this Parliament. And then immediately they rise up.
And then, unfortunately,
So absent that ceremony, isn't it part of the problem that
it's
if we had a ceremony,
yes,
perhaps it would mean if the Prime Minister signed on Friday, the 20th,
yes,
then the ceremony would have taken place on Monday.
precisely.
In other words, MPs would be there, then the prorogation notice would have been given to the Speaker, telling the Speaker, we are giving you this, it is from His Majesty's office. This institution stands prorogued immediately.
Precisely.
This is if you go by the British traditions.
Yeah,
Yes,
tradition.
Yes.
And unfortunately,
Yeah, because our constitution is silent on this.
Yeah.
if I may say something, unfortunately for the British, however developed they are, they don't have a constitution that's written, and we do.
It's codified. They say it's wrong to say it's unwritten. They say we don't have a codified constitution
And that's
because whatever we do is written somewhere, although we haven't codified it in one
as
document.
the court pleases.
Yes.
Now, my lord, His Lordship said something quite important, and His Lordship, through the gauntlet, may I pick an issue with this proposition when probing the submissions of my learned friend. I'm now dealing with prayer 2, the tenability of prayer 2.9, prayer 2.8, I beg your pardon, Your Lordship.
2.8.
The prayer 2.8,
Which subparagraph?
subparagraph A.
Okay.
Now, His Lordship, when probing us, my colleagues, may put a proposition to my learned friend that the coalition agreement is a contract res inter alios acta. I didn't know what it meant, but I had the time to read what it meant. My humble submission, Your Lordship, is that my main discomfort, for want of a better word, of that proposition is that it downplays that contract. My humble submission is that Section 87, subsection 2, which reads, with your permission, my lord and my lady, the king shall appoint as prime minister the member of the National Assembly who appears to the Council of State to be the leader of the political party or coalition of political parties that will command the support of a majority of the members of the National Assembly, unquote. My humble submission, Your Lordship, is that in a coalition government setting, the coalition agreement operationalizes this particular provision to the extent of the establishment of a coalition government. The document cannot be downplayed as a mere contract of no real value in a constitutional scheme of things when, after all, it operationalizes the establishment of a government.
But does it now elevate coalition partners? Or does it, by its existence, divide the powers that vest in the Prime Minister in terms of the Constitution between coalition partners?
It doesn't.
Yeah, that's where we were, that although it might be there, it cannot be suggested that the Prime Minister is then bound to discharge his prime ministerial duties
My humble submission,
in the manner that is being suggested, isn't it?
yes.
Because
That's
every
right.
time when he does something, it would be said, no, since we are not on board here, you
Yes.
cannot do that. Because that would actually paralyze the government, isn't it?
Now, my humble submission is this, Your Lordship, is that the breach of a coalition government becomes a relevant factor to the extent of assessing or evaluating the lawfulness of the decision of the First Minister. Now,
No, but what I'm saying, are you saying it's a legal requirement? Once there's a coalition agreement, then the Prime Minister is legally obliged to discharge his functions
no, I'm not.
in accordance with the terms and conditions of the coalition agreement.
No, Your Lordship, that's not what I'm saying. My basic premise is that the court will recall. When I commenced my addresses on this aspect, I said I harbored the discomfort that this agreement, if His Lordship was to say it's a contract in res inter alios acta, it is being effectively downplayed.
No, it's not downplayed. It only says for purposes of coalescing around an individual in Parliament, because we are looking for numbers. One party can give us a Prime Minister, and if there's no one party in majority, let them coalesce around someone, and that person they are coalescing around will be the Prime Minister. That's a far cry from suggesting that if the Prime Minister doesn't consult his coalition partners, ipso jure, what he does is invalid or unconstitutional. That's a far cry, because I understood the submission by Mr. Ndebele when he started. I thought he was elevating it, he was putting the bar that high to say that the Prime Minister is virtually hobbled by coalition agreement when it comes to advising His Majesty. As a matter of courtesy, of course, the Prime Minister would take on board his partners. Although Mr. Liputi would then say, well, but you see now he should be berated because he then let the second minister advise His Majesty in his presence.
Yes.
You see?
My submissions, Your Lordship, if I may put them differently,
Yeah.
the breach.
What is the legal status? I thought you wanted to submit the legal or constitutional status of a coalition
That's
agreement.
the point I'm just about to drive at.
Yeah.
Now, we have a concept which is recognized by jurists
Yeah.
of a responsible government,
Yes.
specifically in a coalition government setting.
Mm-hmm.
And this is what the jurists have to say, and I quote,
Who's the jurist?
The book, Your Lordship, is authored by my learned friend, Mr. Ndebele, referred the court to this book. May I find a proper The book is titled, we are going to avail all the necessary relevant pages to this court. It's entitled,
And the other side.
obviously to my senior colleague.
Yes. Proceed, Mr.
That's
Rasmus.
the court view. It's entitled, The Veiled Scepter, Reserve Powers of Heads of State in Westminster Systems. The author is Anne Toomey. We have referred to the books in our list of arguments.
Yes.
The learned author has the following to say, and I quote, the source of constitutionally binding advice to the head of state is his or her responsible ministers. This advice may come in a number of ways. The chief minister is the primary advisor to the head of state. It is the chief minister who ordinarily advises on fundamental matters of a constitutional nature, such as the appointment of ministers and the holding of a dissolution. Where a chief minister has lost the support of his or her ministry and party, there is a doubt as to whether he or she continues to be a responsible minister and is thereby entitled to give constitutionally binding advice, unquote.
He is therefore entitled to give constitutional binding advice.
Precisely.
What does that mean?
They,
Because according to this constitution, His Majesty is bound to act in accordance with advice. There's no doubt about that. He's bound to act in accordance with with advice, except perhaps in respect of dissolution, where if he thinks that another member of parliament might command the majority, he can then consult the Council of State to advise accordingly. Otherwise, according to 91, Mr. Rasquai, isn't the prime, this is a constitutional monarch, and according to Makenete versus Lechanya, as a constitutional monarch, he's bound to act in accordance with advice standard.
my humble submission is that
So that if they advise him wrongly, you are not going to come to court to say, well, order the king to do that, issue a mandamus. We should look to his advisors. If they are bad advisors, they should pay, isn't it, legally?
yes,
Because the king, in terms of the precepts, the king can do no wrong.
granted,
He can do no wrong.
granted,
So the wrongs that he does are the wrongs of his ministers.
I accept that.
Yeah.
The point I'm trying to drive at is this, Your Lordship. In probing the lawfulness of the advice,
Yes.
the scholars or jurists
Yeah.
that I have referred to, they project an argument that only the advice of what they term as a responsible first minister can be binding.
But what is responsible? Because I suspect it's being suggested this is an irresponsible prime minister.
That is a,
That's why you say he's even outgoing.
in fact, this is a
So he's irresponsible. Therefore, he dare not advise His Majesty.
yes, he is irresponsible. By the word irresponsible is not used
Pejoratively, yes.
Is used scholarly to mean that this first minister is not responsible to the institution that is supposed to do checks and balances on him. That institution being the legislature.
Shouldn't then the legislature actually sanction the prime minister? Pass a vote of no confidence to say, you are a maverick prime minister, you are irresponsible, we want someone else. So shouldn't the parliament do its bit?
Should do so.
Not to say, but he dare not advise. My only concern is that
No, that's not what I'm suggesting.
if he's irresponsible, he dare not advise.
My proposed argument is that this minister is irresponsible because Parliament, as we speak, was never consulted when this decision that has far-reaching consequences was put in motion.
But I'm saying according to
So
the authority.
advice is therefore, if I may, a product of irresponsible advice by an irresponsible First Minister that bypassed the constitutional mechanisms that dictate that he reports to the Parliament.
Then what should be done with him?
Well,
He should be interdicted from advising,
no,
pending
no,
appointment of another
no,
prime
the court
minister.
has to grant a declaration that the advice was unlawful because it's a product of an irresponsible advice by an irresponsible prime minister.
But that's not the test in terms of the Constitution. The test is whether or not on the section, in terms of 91, the jurisdictional facts were satisfied, Mr. Asquad. Because as soon as you say we should tag him as being irresponsible, on what section, on the basis of his section, would we do that?
91 is the regime.
E.
Because Parliament was never reported.
Sorry?
91 one of the
No, we can merely, he has breached the Constitution, not that he is irresponsible.
well,
In the sense that is being suggested in that book.
yes.
And we know that if a prime minister breaches the Constitution, there are legal sanctions, isn't it?
Indeed.
And there will also be political consequences for which he is answerable to Parliament.
Precisely.
He is legally answerable to the court, but he is politically answerable to Parliament. So Parliament will judge him on the basis of politics. This court will only judge him on the basis of the law, not politics.
Precisely.
So this irresponsibility that the jurists are referring to, is it legal irresponsibility or political
I'm
irresponsibility?
saying legal, Your Lordship, and I'll try to motivate why I say
Yes.
By definition, what the learned authors are projecting is this argument. A responsible prime minister is, or first minister is the one who's accountable to the legislature.
Yes.
Now, section 91, subsection 3, as one of the jurisdictional requirements which have to be fulfilled, it dictates that Parliament ought to be reported.
Yes.
This was never done, after all. Now, by extension or logically, can we say that the advice that was rendered to His Majesty leading to the prorogation, or ultimately leading to the prorogation, was responsible advice when the prescripts of section 91, subsection 3 were never met after all? The answer is inevitably no.
What would happen where the Prime Minister has fulfilled all the jurisdictional requirements, barring reporting? He tendered advice,
Yes.
gave His Majesty, put His Majesty in mora, as my learned brother was suggesting. His Majesty doesn't come to the party. Basically, they don't find each other. Then ultimately he says to His Majesty, I'm minded now to invoke my powers under 91.3, if by such and such a time His Majesty has not done anything, and that time comes and passes, and then he does what His Majesty was supposed to do. But the only problem now is that he fails to report to Parliament by virtue of the fact that Parliament is no more. So that he has only failed to meet one condition, the others he has met.
It's a pronoun scripture, Your Lordship, in my humble submission.
The reporting.
Yes, it can't be done away with in our constitutional setting. It can't, in my humble submission. And this is exactly what happened.
So you are saying, in other words, you are suggesting that failure to report itself nullifies everything.
My humble submission says that.
That's the irresponsibility you are talking about.
That's precisely the irresponsibility that...
Yeah, but that's failure to comply with the section. Not the irresponsibility in the terms in which the jurists that you're quoting are suggesting.
Well,
that's why I'm saying, it connotes politics, you see, Mr. Asquai, to say the court can say Prime Minister is irresponsible. We can merely say the Prime Minister failed to follow the Constitution.
Well, I'll leave it at that, Your Worship.
Yeah.
I won't pursue this point any further.
Perhaps, Mr. Asquai, before you proceed any further, I just want to get an understanding as to when the reporting, according to you, has to be done. Are you saying the reporting to the Parliament should be done before the actual gazette is issued.
That is my humble submission, Your Lord. My Lord,
It's 4:30. I just wanted to find out from council. In terms of the COVID-19 regulations, is movement not supposed to cease at 4? Or is it 6?
Lord, I can't drive by myself on the lone road from here to Ribe in this circumstances.
Yeah, that's why I was going to suggest, Ms. Taylor, whether it's not a convenient
It's a convenient time
to adjourn so
That's the court.
so that we don't cause you to violate the regulations itself. That's what I was going to suggest. Maybe it's a convenient point at which you can adjourn, and then you can advise us to the way forward. What should we do?
Can we?
Yes.
It's acceptable to yourselves. May we come back tomorrow?
Tomorrow, Mr. It's just that.
If it is acceptable, it's convenient.
No, it's really not a matter of convenience. It's only that really we hadn't envisaged that. Because we were going to suggest that let's proceed on Monday at 10,
That's the court.
because my colleague, Banjani AJ, is on call, but she'll only be handling bail applications. And she might be through around 10. So can we not make it 10?
I hope that I will not have lost the momentum.
I hope that we are right.
No, you won't. In fact, you'll have an opportunity to digest all the issues that we are raising. And I suppose you're even going to be shorter when you address.
I will be short.
Yeah, and then you'll also have
I'm
an...
done, Your Lordship.
Sorry.
I'm done.
No, I know. And also, Mr. Mulati, Mr. Taylor said he doesn't have sight of some of the papers that you prepared. Can you avail them to him during the course of the weekend, if not today, so that on Monday when we come, everyone is on the same page?
I will do that right away.
Yes.
All I can say to the court is I've just got a few things to touch on. You should actually be in the position to be prepared.
Yes, no.
Mr. Rasco is that.
Yeah, but please make sure that your learned colleagues have your papers, so that on Monday we'll move faster. The court adjourns until Monday at 10.